Laura, tell me something that you think people don't generally know about starting a business.
The concept that once they get filed with the state and maybe get a tax ID number, that's it, they have a business. When from a legal point of view, there's a lot more that needs to be done to protect their rights.
That's true. Many people think that by registering with the state, they have essentially completed all the legal documentation they need, but the state's interest is a little bit different. The state is interested in having you register so that you might potentially be a taxpayer. And so the important thing there is they want you to get a tax ID number. They want you to be registered in their database. They want you to file all sorts of forms that relate to collection of money. Now, there are other things the state may be providing to a new business, and I don't minimize that, but I don't think that the state is as thorough in protecting a business owner's rights, such as in showing the business owner what bylaws to use and how those bylaws should be structured and what kind of resolutions they need and how they should structure their shareholders agreement. I don't think those things are generally things that the state is involved in. That's more a private attorney. What do you think?
Absolutely, and the real reason a lot of people form the business is to avail themselves of the protection of the liability shield. They want to operate out of a corporate entity rather than individually so that they can protect their individual assets. And just forming the company with the state and doing nothing else doesn't accomplish that. If you're actually sued in a litigation in your individual capacity, you're going to want to show all the appropriate legal documents were put in place to be able to get out of that individually and make sure it's the company that's liable.
And the emphasis there is that none of that is a guarantee. In other words, you theoretically could have a corporate liability shield by just filing with the state and doing nothing, or you could lose your shield if you filed with the state and did everything right. Nothing is 100%. It has to do with the facts of the case. It has to do with why we're even discussing it. Is there a litigation over it? Is it a tax matter? Is there some involvement with individuals being sued for fraudulent acts where the corporate liability shield might not even apply? But the important thing is that overall, it is generally better for a business to have its documentation done properly, and that means bylaws, resolutions, shares being issued for a corporation, and it means an operating agreement, similar resolutions as well, but no shares, for a limited liability company, and of course for a partnership, we're talking a partnership agreement.
And one of the other critical reasons you need that, take it away from the litigation side, is if you don't have those agreements in place, then you're stuck with the default that are the corporate statutes. So if you don't like the way profits are allocated and management of the entity is allocated in the Limited Liability Act or in the Corporations Act or the Partnership Act, you're stuck with that unless you have an agreement that says something otherwise. So all of that is to say it's really important that you make sure those documents are in place.